Thank you very much. It's my pleasure to welcome you all here tonight. And in starting, I would like to acknowledge that we are on the traditional, unceded, and ancestral lands of the Musqueam and Coastal Salish nations. And we are very honoured that we are able to be here tonight. We have tonight a fabulous panel. Before I introduce the panel, I would like to say a few things. This meeting is actually the first, as far as I know, collaborative effort between the Faculty of Forestry and FP Innovations. I told you, Ian, I'd surprise you. We had some discussions about how we could work together better. And one of the things that came up was maybe we could organise a meeting on the decision that we're going to be talking about tonight. Unfortunately, the senior team from FP Innovations were then called away over to the east. They're not here tonight, but there are some representatives here. And I hope that in future we will have further opportunities to work together. We're very grateful tonight for the reception that was laid on by FPAC, the Forest Products Association of Canada, and the Canadian Council for Aboriginal Business. I'd like to acknowledge their support. And they are also supporting the photographer, who's going to be here for the first few minutes of this presentation. Tonight we are addressing one of the most important issues in forest and land use policy that has come up in recent years. It is the Chilcotin or Tsilhqot'in decision. And we have a number of individuals who are very familiar with this. And really our first speaker is the most familiar since he was the plaintiff. And it is Chief Roger William. Chief William is chief of the Tsilhqot'in First Nation and has been chief for the last 19 years. He's also been a council member there for 5 years. He acted as the Area J Director of the Caribou Regional District from 2011 to 2014. He was born in the Namaya Valley, and he holds the traditions of the Tsilhqot'in really closely. He was the plaintiff in the recent Supreme Court of Canada decision, which granted full Aboriginal title to the Tsilhqot'in Nation in his traditional territory. He has been Vice Chairman of the Chilcotin National Government for the last year, and he, in that role, has been striving for economic development in this sensitive, or economic development that is sensitive to Aboriginal rights and title, to the environment, and to the culture of the Tsilhqot'in. He is married and is the proud father of 4 children, I understand. He is accompanied tonight by Jay Nelson. Jay is beside him. Jay is the General Counsel for the Tsilhqot'in National Government and Associate Counsel at Woodward and Company. He was part of the team that, at the trial of the Tsilhqot'in Nation's Aboriginal title and rights claim. He was there on appeal before the BC Court of Appeal, and finally at the hearing before the Supreme Council of Canada. The two of them will be giving a presentation together, I understand, and the questions will all be answered by Jay at the end, particularly if they address legal issues. So I would like to invite Chief Roger William to start the evening with a description of the case.
Good evening. I don't know if you can hear me. Chanaya. Chanal in Musqueam. Nandiyan ako ng Tsilhqot'in. It's an honor to be here. Thank the Musqueam First Nations for being on their territory. I just wanted to start by just saying that this is such a huge, very honoring process, and having you all here, I'd like to thank each and every one of you, because tonight is communications and talking about this huge decision that never happened, let alone in BC, but in this country or in this world. This is huge. So with that, I just wanted to start by the claim area, just give you a good idea of the size of the court case claim area and in terms of where we are in BC. In terms of the background, Tsilhqot'in, we are one of the 6 Tsilhqot'in communities. A lot of our elders in our communities don't really understand or speak English, and I've learned English in St. Joseph Mission in the residential school. We're unified as a nation, really coming from our Chilcotin warriors, the leaders of 1864, the Chilcotin War. Tsilhqot'in is remote. We're right in the Cascade Mountains, and very strong traditional culture. Provoked by the Forestry, by logging coming into our territory, plans for extensive clear-cutting. And one of the areas of the last areas in the Tsilhqot'in that's pristine. So if you were to go back into our area in the early 1900s and today, it wouldn't look much different. It's very sacred. Tsilhqot'in is caretaker of this area.
I might just step in here to speak to the satellite photo that you see there in the background. It gives you a sense of how important this issue was for Tsilhqot'in. You can see the claim area is bounded by the 2 rivers that form a triangle that goes up to the top of the screen there. And on the bottom here, the blue is not water, those are mountains, it's high altitude. And the beige that you see are clear cuts. And so you'll see up until then there's extensive clear cutting basically right up to the boundaries of the claim area. And the court case was initiated when the plans were to go into that remaining pristine area to continue logging.
We call this area Tsilhqot'in in our language, also known as the Brittany Triangle. On May 7th, 1992, Henry's Crossing roadblock, a 2-month process, which the company agreed to not log in the trap line from our 1990 filing of the trap line case. And this same company wanted to get into the Brittany Triangle without really consulting or working with us. So this was a place, a time where the Tsilhqot'in Nation, Tsilhqot'in, local operators in the area, non-First Nations, tourism ranchers that were involved in that. And Brittany Lake's forest management plan between 93 to 97, mimicking what we call in our history is managing forests, how it was done in the past where there was fires used. But we as Tsilhqot'in have been working on ecosystem-based planning, and that plan was, we had a lot of work done there, but because of the legislation of the province, it was rejected. So the frustrations, the Ministry of Forest, the company, and ourselves couldn't come up with an agreement. So as far as we knew, in 1998, the Brittany Lake Forest Management Plan, strategic plan was going to go ahead whether we liked it or not. So we filed a title case. So this BC Supreme Court trial lasted for 339 days and 5 years. We had about 29 of our elders from Hani and the Tsilhqot'in communities testify. A lot of experts that were involved and lots of documents. The judgment on November 20th, 2007. Aboriginal rights throughout the whole court case area was granted, including a right to capture and use wild horses. So rights to trade skins and pellets for moderate livelihood.
So the next finding might be of particular interest here. And the court found that because of the finding of Aboriginal rights to hunt and trap and trade throughout that entire claim area, that the forestry plans and the licenses that have been issued were an infringement of those Aboriginal rights that couldn't be justified, and so it couldn't proceed. And the rationale that the court gave was essentially that the planning didn't demonstrate that Aboriginal rights and the continuation of those rights was a priority. There wasn't, well, the example you'll see here is there wasn't a database of the wildlife populations in the area. There's really no sense of what the wildlife populations were or what the Tsilhqot'in and Tsilhqot'in required to sustain their culture. And the court said that these Aboriginal rights have to have some meaning. They're meant to exist in perpetuity, and essentially concluded by saying, given the finding of Aboriginal rights throughout that entire claim area, what it really called for was a new model of sustainability for forestry. And there's some discussion of what sustainability means in a forestry context, and it essentially means the sustainability of the harvest, but calling on the government to import cultural sustainability and the sustainability of Aboriginal rights into the analysis as well. I'll just continue for another slide or two. The court did go on to find that the evidence had proven Aboriginal title to a significant portion of the claim area, about 40%. It's the darker green swath through the center of the claim area you can see there. It found that the evidence had established Aboriginal title, which is more in the nature of an ownership right to the land, as opposed to Aboriginal rights, which tend to be about a right to undertake certain activities. Aboriginal title is a much fuller right, somewhat similar to ownership. But at the end of the day, at the BC Supreme Court, at the trial level, the judge, although he'd found that the evidence had proven Aboriginal title, felt that he was barred from granting a declaration of title, which would have given that finding legal force on the ground. And the reason is a technical legal reason that honestly I don't completely understand myself. But if it were to be summarized, it's that the plaintiff, Chief William, had in his pleadings asked for Aboriginal title to the Brittany Triangle and the Trapline territory that you'd heard him mention. But he hadn't specifically asked for title to lesser areas, if that's what was made out on the evidence. And so because that title was only made out to 40%, not to those larger two areas that had been pleaded, the trial judge felt that he couldn't grant a declaration of Aboriginal title to that 40% area. So as a result, at the end of trial, nobody was satisfied across the board, and we all ended up in the BC Court of Appeal not long after that.
So we went to Supreme Court of BC appeal, and the decision from that from 2010 to 2012, that's how long it took to do a 6-day appeal, when it took 339 days for the trial and the decision coming down within months. So it kind of gives you a good idea of the significance of the decision. But in terms of Aboriginal rights, that was a huge decision. The BC appeal upheld our rights to hunt, our rights to trap, to trade, and on top of all that, rights to catch and use wild horses. So that was a significant and a huge victory. That was very, very important. In terms of the infringement, the Court of Appeal upheld that any forestry planning and licenses that's unjustifiably infringe on our rights, that it could not, that can't happen in the whole claim area. So that was another huge victory. In terms of title, we looked at the Vickers decision, and I said earlier, almost 40% was proven title. When we went back into the appeal of Supreme Court of BC, we appealed that it's 100% title. If not, at least what the trial judge decided. So that was what we put forward.
I feel like I'm getting all the slides that are bad news for us, but this is where things fell down at the Court of Appeal. The Court of Appeal found that that whole issue around the pleadings wasn't really a problem, and the trial judge could have declared Aboriginal title if he'd felt it was supported by the evidence. But the Court of Appeal found that the trial judge was wrong on the law. They disagreed about the law of Aboriginal title. And what they said was, regardless of the evidence or how the land is used in any case, just as a matter of pure law, Aboriginal title can never exist beyond specific intensively used sites. So the trial judge had found title to 40% of the area based on regularly used hunting grounds, tramping areas, gathering areas. The Court of Appeal said that's wrong. You can't have title to a hunting ground, but you might have it to a specific spot like a salt lick or a narrow space between cliffs where you can hunt game very intensively on one spot. And in fact went so far as to say you might get title to a rock. That's in the quote you see here, if you stood on it to gaff salmon. But that's how narrowly defined title was. And the trial judge, that was the position of the Crown, both BC and Canada. And the trial judge had rejected it at trial, calling it a postage stamp approach to title, an impoverished view. But that's where the Court of Appeal ultimately landed on that issue.
So we went ahead to Supreme Court of Canada, and we looked at it, and the only appeal that we put forward was this title decision that Supreme Court of BC Appeal made. This was a really tough one because we've listened to and talked to many First Nations, our people, our elders, and our leaders. And appealing this is one thing. What are we going to appeal is another. And it was a strategy that we thought in many ways was a tough one to swallow, especially for me, in terms of the size of the area we're going to appeal. So we thought in the strategy-wise, and we carefully worded, so that at the end of the day, that in the future, whatever decision came, it does not infringe or impact the areas of that proven title, which is in the Declaration of Rights. That in the future, if we want to go and actually either go to Supreme Court of BC and go a small spot title claim, or go back to Appeal Canada and go for the whole. So that was the strategy, and what we put forward was the Judge Vickers' decision on proven title area. So the decision was huge. I was before I left. This is one of our young. We have a couple of students here in UBC. Jimmy Lilua and his wife June Cahoose Lilua. They're here. They're the ones that started what we call the Tsilhqot'in Youth Wagon Trip 5 years prior. This was the 6th year. And when I was a child, I had the only way I got to the Williams Lake Stampede was by horseback or wagon. So this is our 6-year trip, and before we left, I had a text from Jay that the decision's coming down on June 26th. So before we left that wagon trip, I reported to our people on that wagon trip that the decision's coming down. So that means partway through the wagon trip, I got to leave. So I was smelling like smoke and everything when I came to Vancouver. And I got to Vancouver on the 25th, and I never really slept, never really ate. And thinking, 2 years ago today, Supreme Court of BC appeals that we got small spot postage stamped style title. Now tomorrow morning at 6, decisions coming down, and man, it was huge. unanimous. You know, we were thinking on November 7, 2013, we had this drive. We had all our elders and members who were in court. We went right across Canada, and this title drive where we met First Nations across the province and leaders and doing ceremonies, drumming, and then being in court and knowing that there's only 8 judges. You know, you think back of 1973, the Calder case, the Calder decision, hanged jury. You know, we're thinking, wow. But when after that day, when we listened to the arguments and what the judges were questioning, we were feeling pretty confident. But here, never ate, not drinking, couldn't even sleep, and it's on the 25th, and I'm just like, wow, there's 8 judges, what could happen? But when that decision came down, 6:30 in the morning, I was just blown away. 8-0. Aboriginal title, first ever in BC, first ever in Canada. That was huge. So this decision that came down throughout Supreme Court of BC appeal, postage stampage style, small spot, standing behind a rock blind or on a rock, you know, threw that out. And then that we won. You know, where we hunted, where we camp, where we trap, where we live, because we organizedly, our families, our villages, our communities go throughout this whole area. Some areas we don't go until every 2 years or every 4 years, some areas every year, but it's done in a way that it's done for thousands of years. So just to get that recognized was huge.
So just very quickly on what Aboriginal title is, you probably know, but the court confirmed that Aboriginal title is essentially a form of ownership, collective ownership by the nation. It's the right to control the land and decide how it will be used, to use the land for traditional purposes, but also for modern purposes, if that's the desire and wish of the community collectively, and the right to the economic benefit of those lands and resources. It gets a little bit more complicated than that in the decision, but that gives you a sense of how full a right that is and how close it is to a form of ownership. And then the next part of the judgment dealt with the intersection between Aboriginal title and provincial regulation and federal regulation. There's still probably a lot to say about that and a lot to explore about that in the days to come. Very briefly, the court said that the province and Canada do have the ability to infringe Aboriginal title lands, but they must first seek consent from the First Nation. Otherwise, they have to meet a strict standard of justification. Without going into details, there's a number of suggestions in the decision that threshold will be very high and demanding, in part because they say that the Crown is required to show that the objective will further reconciliation. So that's probably a fairly narrow range of activities where the nation is objected to and it's happening without their consent, but it would still be seen to further reconciliation. So that remains to be developed, but it suggests the bar is quite high. And the court confirmed that the forestry planning and land use planning, forestry authorizations in this case, unjustifiably infringed Chilcotin Aboriginal title. I'm not going to get into this point because I know we're running out of time here, but I thought it might be of interest for this particular audience. And that is the court's conclusion, just as a matter of statutory application, that the Forest Act doesn't apply to Aboriginal title lands once those lands have been declared Aboriginal title, such as the Chilcotin title lands in this case. The reasoning being that on its face, the statute regulates Crown timber on Crown land. And the court said once title is declared, it's no longer Crown timber, it's no longer Crown land. It vests in the Chilcotin people. So Chilcotin timber on Chilcotin land. So they said just as the Forest Act doesn't apply to private lands, it doesn't apply to the lands owned by Chilcotin people, as it's currently drafted in any event.
So with that, Aboriginal title exists in large territories, and we have control benefits and in our traditional lands and resources of our tidal lands. And hunting and trapping calls for a new model of sustainability, and that's, cultural sustainability. And a watershed moment for BC in Canada, an opportunity from this decision to move forward based on what their highest court in this country told them. And how you're going to do it is going to be very, very important. It's such an opportunity for all of us. With that, I just wanted to take this time. Also want to say that First Nations in this province, across this country, Sachanaya, thank you for all you've done, all your meetings, all your lobbying, all your direct actions, all your treaties, all your court cases, and being out on the land, speaking the language and using the land. Sachanaya. Thank you.
Thank you very much for that presentation. Who better to explain the case than the plaintiff himself? Thank you for coming down and doing that. We felt it would be very useful to get some reactions and some commentary from some of the other people who might be involved or are involved or who there are ramifications for, because as Chief Williams said, this is a watershed moment. Things are going to change in this province as a result of this decision. And I think it's very important to actually try and understand the broader implications of this. And so we have three speakers here tonight who will give their reactions to this and explain what they consider to be the implications. The first of those speakers is Douglas White, JD, who is a member and former chief of the Snuneymuxw First Nation in Nanaimo. His Coast Salish name, and I wasn't able to check this beforehand, so please forgive me if my pronunciation is wrong. His Coast Salish name is Chilcotin, and his Chalnuth name is Tsilhqot'in. After completing his BA in First Nations at Malaspina, he graduated from the Faculty of Law at the University of Victoria in 2006. He was called to the Bar of British Columbia in January 2008 and has been director of the Indigenous Bar Association of Canada and an associate lawyer at Mandalpinder. He was elected chief of the Snuneymuxw First Nation from December 2009 to February 2014, and he has been working on the implementation of their treaty from 1854. He was elected by the Chiefs of British Columbia to lead the First Nations Summit as a member of the FNS Task Group, and in that capacity he has been advocating for First Nations seeking resolution of outstanding issues with the Crown. He's also in that role been a member of the BC First Nations Leadership Council, working on common issues with BC First Nations, particularly the Crown's duty to consult and accommodate. He's currently the director of the Centre for Pre-Confederation Treaties and Reconciliation at Vancouver Island University and practices as a lawyer and negotiator across the country for First Nations government. He's also an associate of First Peoples Law, where he is counsel for First Nations across the country. Welcome.
Okay, I'm going to stand up here. Asiam Nasiaya, Ainthapek Palosalton, Tanis Lanemo, Aitna Shkwalaman, Konas Ihi, Heitsepka, Siam Stimoch, Heitsepka, Musquim Stimoch. Good evening, everyone. My name is Cole Osselton, Cletion, Doug White. It's a great honor to be here. I want to give recognition and respect to my Musqueam relations that were gathered up in their territory. And I want to thank Andrea and the UBC Faculty of Forestry for inviting me to this important event. It's a great honor to hear directly from Chief Roger William and from Jay their reflections and their experience of going through this remarkable bit of history. And this is truly a historic moment for all of us in this country. The decision from June 26, I remember that 6:45 a.m., I remember being in my hotel in Vancouver too, waiting for that decision to come down, is the product of all of your efforts and all of the efforts of First Nations over the course of well over a century. This has been the single most important public policy issue that's been at the core of Crown First Nations relations for well over a century. The very first Aboriginal political organizations that were formed across British Columbia were formed around this issue and this question. This constant refrain from Indigenous peoples standing up to the Crown and asserting and making clear that their relationship with their territories is important, that it's been overlooked, that it's been denied, and that this is not a correct way to go on about establishing a society and developing a country. That there's real work and real issues for us to talk about and for us to sort out. We know that where I'm from, I come from a bit of a strange place in BC history, from Snuneymuxw, over right across the water from us in Nanaimo, where on December 23rd, 1854, the last treaty from the Pre-Confederation era was made. There was 14 on Vancouver Island. When the colony of Vancouver Island was seeking to establish itself down in Victoria, in the southern part of the island, where they were seeking to develop a settlement, they knew, and it was not even a controversy at the time, that before settling on Vancouver Island, a basic requirement of English law was for them to give recognition and respect to the Indigenous peoples and to come to an understanding with them about how we're going to live together. And so a number of treaties were made down in the Victoria region, 11 of them. 2 more were made up in Port Hardy with now today the Kwakiutl First Nation, they call themselves, are the inheritors and the benefactors of those 2 treaties. They were made because of the thought that there might be coal in their territory and that the Crown was seeking some kind of a resource to build an economy around for the fledgling colony. Likewise, where I'm from at Snuneymuxw, there was a discovery of coal or recognition that there was coal in our territory. And it was a matter of course at that time that as part of the Crown's seeking to build economic activity around that resource, they had to come to an understanding with my ancestors and my people, and they did that over the course of a couple of years of negotiations. But unfortunately, after December 23rd of 1854, a different pattern took root in the province that has configured so much of the politics, so much of the law, so much of the economic relations and social relations in BC. This idea that somehow Aboriginal title, you know what, it's a little bit too complicated and expensive to deal with. James Douglas had written to London asking for further resources to continue on with treaty negotiations, and the Imperial government made clear that that's not a job for the Imperial government to be funding or to be worried about, that that's a local issue for the colony to uphold. For various other reasons, they shifted out of this treaty-making approach and moved into a different kind of pattern where you could safely say it was more of an administrative relationship and not a relationship of equals or nation to nation or government to government, but the relationship collapsed into something quite different from that. That basic issue for the last, from the 1860s through into the turn of the century was a key part of the dynamic between First Nations and the Crown, including with the Chilcotin peoples. The Chilcotin War and all of the issues that took place there are a key example of the brokenness of that approach. Now, I think it's important to note and recognize the continuity of the advocacy of Aboriginal peoples and to give recognition and respect to the law in depth and the law in tradition of standing up for what they believe in relation to their proper relationship with their territory. At its root, this is an issue about basic human dignity and recognition and respect of each other. That Aboriginal title is a reflection of a core component of the identity of Indigenous peoples. That there can't be an Indigenous people without an Indigenous territory. That there can't be an Indigenous individual without their Indigenous nation of people. That these three key components are all inherent in their nature. That there's something about this the particular framework of existence in this part of the world that continues to mean something and must continue to mean something. And we know the long history of the work and the efforts to knock down all of those basic components, to strip people of their Indigenous identity has been a major project for a very long period of time. To deny the relationship of Indigenous peoples to their territories has been a key project for the Crown. When the last major political efforts of Indigenous peoples in the early part of the 20th century, Andy Paul and Peter Kelly, a Squamish and a Haida man, leading up the Aboriginal peoples of British Columbia to go and continue on the work of advocating in relation to Aboriginal title, saying to the Crown that the Douglas Treaties on Vancouver Island must be respected and implemented, and that the Aboriginal titles of all of the people in British Columbia is a real issue that must be discussed and resolved. After a period of years, the federal government finally established a joint committee of the Senate and Commons to hear what they had to say. For God's sakes, can we please stop hearing what these complaints of these people? Let's invite them out and hear what they have to say and come up with some kind of an approach. The answer they got in 1927 was an amendment to the Indian Act that prohibited Indigenous peoples to hire lawyers to talk about the issues of land claims. And so it was a deepening of denial, so much so that while that law was in place that prohibited this kind of advocacy up until 1951, it wasn't until a couple of Snuneymuxw people were hunting in Nanaimo and were charged for hunting deer out of season in the summer of 1963, and when they stood up in the court the next day in front of the magistrate and said, our answer to this charge is that we have a treaty, they called it a treaty of peace, between our First Nation and the Crown that recognizes our right to do what we were doing, to hunt in accordance with our own laws and traditions. This is now 110 years after the treaty from 1854, and so deep is the history and the patterns of denial and the suppression of knowledge of a different kind of relation that neither the magistrate on the bench nor the prosecutor in the courtroom had any idea what these Aboriginal peoples were talking about. What a remarkable place to be in. My people brought that issue to court. They brought in Tom Berger on appeal and went through the county court, the BC Court of Appeal, all the way to the Supreme Court of Canada, and had the court recognize that, in fact, there is a treaty relationship between the Snuneymuxw and the Crown, that it continues to mean something today, that it will be legally, that it's legally enforceable, and that what it means in this context is that the provincial law cannot apply to interfere with the operation of the Snuneymuxw hunting rights. Now, that's this is the first opening of the modern era of Canadian Aboriginal law. That's the first statement in the post-prohibition era in terms of legal advocacy. In that case, what Berger, and we had Frank Calder was a key political ally. He was an MLA at the time. Guy Williams from the Native Brotherhood of British Columbia. All of these central individuals and the political organizations were supportive of the litigation. And what was put forward was that in the first instance, the first line of argument was that the Snuneymuxw people have a treaty. The second line of argument was that the alternative argument was that if you're not going to recognize that there's a treaty, then we're going to talk about Aboriginal title and Aboriginal rights that protect the hunting activity of White and Bob. And we were successful in the first line of argument, and then Calder and Berger brought up the second line of argument in the late 60s into the early 70s in the Calder litigation. This opened up a very critical and important series of cases that culminated this summer in June. And there was something, this was a decision on June 26th that was very critical in a lot of ways. For many years, from the Calder decision through the Delgamuukw litigation, through the trial and the appeal level of Chilcotin, we faced, Aboriginal peoples were faced with a reality that the judges have made clear in very real ways that they feel that it's not their proper role to be making Aboriginal title declarations, that there's something about the complexity of this as Aboriginal title and its recognition is a core issue at the relationship between Crown and First Nations that is best dealt with in the political sphere and realm. And it had become clear that in some way what's developing is something like the American political question doctrine, that there's something that's, they're quite happy to make jurisprudential and theoretical statements about what Aboriginal title is, but they're in no way are they going to interfere with political discussions about that very issue itself. And so this is obviously a significant problem and had been a significant problem. A part of the reason why judges were willing to take that position was because of the establishment of the BC Treaty process in the early 90s. That was a key component, I think, of why they were willing to do all of these ridiculous judicial acrobatics that Jay referred to, find all of these nonsense technical reasons not to make a decision. Because of the horrible decision of the BC Court of Appeal and because of the horrible failure of the political discussions in this province to be productive of any meaningful recognition of Aboriginal title, in some ways it put the Supreme Court of Canada into, it boxed them in and jammed them and put them in a corner where they had to make a real decision about whether or not the legal process would continue to play any kind of a meaningful ongoing role in resolving what has been the central issue in BC history. And so they did. They made a remarkable decision. Now I want to talk a little bit about what Aboriginal title is, because I think it's important to recognize that it has both, it inherits some of its framework from property law, but I think it inherits, more importantly for our discussion tonight, it inherits a significant and has its foundation importantly in law related to Crown relations with public property. That this isn't just a mere private relationship with a piece of fee simple land that's held collectively in some weird way. You'll see the courts have always sought to avoid talking about jurisdiction in important ways throughout the development of Canadian Aboriginal law. You know, we have the most important political statement that could ever be uttered in the Constitution of Canada, Section 35, that the Aboriginal and treaty rights of Indigenous peoples are recognized and affirmed. We've got the most important, profound statements of the Supreme Court of Canada over the past 50 years. It's important to note that when I showed up as chief in 2009, that Supreme Court of Canada decision from my people in White and Bob in the 1960s effectively meant nothing in the lived lives of the Snuneymuxw people half a century later, 2 generations later. This is a place that we cannot continue to be in. The courts have said and pleaded with the Crown to get on with the important work of seeking and building reconciliation with Indigenous peoples. The court has said clearly that that consent and involving Indigenous peoples in decision-making about territory in British Columbia is now an important new model. It's a fundamental legal principle of Canadian constitutional law, the idea of consent. When we think about BC, and 95% of it is Crown land, we now know with some clarity that Aboriginal title is territorial in scope. The implications are obviously profound. My understanding is that it's paralyzed the provincial decision-making process inside the Ministry of Forests in important ways, having to figure out and grapple with that reality. We're in a moment, we think about old statements of the Crown and things like the Royal Proclamation. The Royal Proclamation, at its root and at its heart, what it said is that Indigenous territories are reserved to them to prevent frauds and abuses being visited upon them by local interests. That territory cannot be touched by Crown subjects until the Crown enters into a formal relationship with Indigenous peoples. That settlement can unfold, that development can unfold underneath those arrangements. There's been a very disturbing pattern in the development of Canadian Aboriginal law since Sparrow, where this idea and the impulse and much of the effort and time of the courts, and certainly much of the arguments of the Crowns, the Attorney General's offices and the Department of Justice across the country, has sought, rather than to seek development of Aboriginal law for the purpose of repairing the damage that's been done to Aboriginal peoples across the country over more than a century, you start to see decisions that are less about creating a positive space for Aboriginal peoples to stand on in relation to their rights and their territories, and more of a focus on what is the Crown's capacity to infringe those rights. And in the Sparrow decision, there was a really unfortunate decision to create an analogy to the Crown's capacity to infringe upon the charter rights of Canadians. The judges thought, well, Section 35 can't simply stand on its own and be some kind of a ground of absolute rights of Indigenous peoples. Surely there must be some way for the Crown to interfere with and infringe on those very rights. The challenge now that we're in is that where the First Nations are now fundamentally equipped by this statement of the courts that the courts are sick and tired of waiting for a Crown that is not undertaking the job of reconciliation with Indigenous peoples seriously. And that we are going to make an expansive statement about what Aboriginal title is. The world is a fundamentally different place. Consent is a fundamental principle that must now find a home in the relation at the core of the relationship between the Crown and First Nations. What a departure from the weak and impoverished approach to the Haida Nation decision from a decade earlier. This is a moment of transformation. This is a moment when we must shift. And we've seen already from the provincial government statements that, to the effect that, writing to in letters to First Nations, such as the Nak'azli recently, where they wrote, Chief Sam, it's important for you to know that the Chilcotin decision about Aboriginal title, keep in mind that the only Aboriginal title that's been recognized is with the Chilcotin people. And that until you prove your title, until you go through some process, we're going to continue to operate in a way where we ignore that reality, that the world is a different place. This is an impoverished approach that will not deal with or contend with the deep uncertainty of the place that we're now in. It's a moment for all of us, with the assistance of faculties like this, delving into the policy implications of this decision, to help give guidance to both First Nations and the Crown about what's required at this time. If we don't grab a hold of this moment and show leadership, the relationship will collapse into deep uncertainty and conflict, and it will grind the forestry industry to a total halt. Because there is no doubt, as I spoke in my advocacy to Justice Groberman's decision, that horrible impoverished decision, that seemed to want to say to Aboriginal leadership, get back on your reserves and sit down and shut up about Aboriginal title. Because the reserves that you already have are probably more generous and expansive than any Aboriginal title you might be entitled to. That idea, to be able to state that kind of a thing in this day and age is shocking. It demonstrates a shocking lack of an appreciation of the development of First Nations advocacy and their capacity to stand on their feet and to protect and to seek to protect their territories and to seek to reestablish the territorial relations that they have with their territories. So that's the challenge in front of us, and I implore and encourage everyone to be involved in that transformative discussion, to show leadership, to seek to take and provide advice that's necessary to avoid the depth of the uncertainty that's the alternative. So I hope that those few brief comments are of use and prompt discussion. I'm happy to have the opportunity to share a few words with you, and look forward to the conversation. Thanks very much.
Thank you very much for that presentation. We now have two other speakers. Unfortunately, Angeline Nyce is unable to be with us tonight. She let us know only just before the start of this that there was an emergency that had cropped up, so she's unable to be here. But our next speaker is Tim Ryan. Tim is with the Forest Practices Board. In fact, he's the chair of the Forest Practices Board. He's worked in the forest sector for more than 35 years and has held leadership positions in British Columbia, Alberta, Manitoba, Ontario, and even Minnesota. He came to the Forest Practices Board in January 2014, having previously been the Chief Forester and Director of Woodlands Operations with Vancouver's Leadcore Resources and Transportation. He spent much of his career with Ainsworth Lumber, where he was Vice President responsible for timberland operations, corporate and environmental policy, and bioenergy. He is a past president of the Alberta Chamber of Resources and former board member of the Alberta Forest Products Association. He is a registered professional forester here in BC, and he's a fairly rare person because he holds a Bachelor of Science degree in forestry from the University of Alberta. We do allow them occasionally to cross the border.
Hey, golden bears forever.
So, Tim Ryan will present the views of the Forest Practices Board. Those of you who are familiar with the Forest Practices Board will know that they've been issuing some reports recently that are critical of a number of different organisations, including both the forest industry and the government. I'm thinking of the Tsilhqot'in Channel report, which I found very interesting. Thank you.
Thanks, John. Thanks, John. Good evening, everybody. Gentlemen, well said. Opening remarks. Tim, you got a long road ahead of you. And good evening to all the students. I see some colleagues ahead of us in the audience here, some colleagues of mine, some peers. And I said the students already. It's an interesting evening for me so far, so I'm very honored to be here tonight. Thank you for inviting me, Andrea. It's going to be fun. So, I'll carry on with Doug and Roger and Jay. They covered some of the ground I was going to cover, and I'm going to take a little bit different tact on that ground as I go through it, so it's good. We live in interesting times for many reasons. In today's discussion, it's due to our failure as a society to resolve First Nations issues politically for over 100 years. We are now in the process of reacting to court decisions. So I'm going to speak to you as a forester who's spent 35 years in the industry and as chair of an organization that acts as the public watchdog for sound forest practices in British Columbia. As foresters, we care about the land. I want to talk about what the implications of the Chilcotin decision might be if we see it replicated across the province from the perspective of the land and its resources. At the Forest Practices Board, we provide oversight on forest practices, independent of government and forest companies. So I'd like to talk a bit about the benefits of independent oversight and how it could be useful to First Nations and others in this context. So let's start with the Chilcotin decision. It is significant, and it will take time for us to get our heads around all the different aspects. It will be interesting to see how the Chilcotin Nation and the province move to implement the decision. Just think about what the Supreme Court has said. The land in question is no longer Crown land. The land and the trees belong to the Chilcotin Nation. The timber is no longer Crown timber, and the Forest Act does not apply. The size of the Chilcotin land is about 170,000 hectares. The Nisga'a lands under the Nisga'a Treaty constitute 200,000 hectares. And for comparison purposes, Bower and Lakes Park, which many of us have canoed around, is about 150,000 hectares. Or Silos Provincial Park, Chilcotin Lake, sorry, I didn't get it quite that good. But anyway, Silos is about 230,000 hectares. These are sizable areas of land. We can certainly expect more areas of treaty land in the future. According to the BC Treaty Commission, 44 First Nations are currently negotiating agreements in principle. Some of these treaties could involve sizable areas. In addition, now that the Tsilhqot'in Nation has been successful in proving its title claim, we can probably expect other First Nations to take the court route and seek declarations of title. What is emerging, then? Will it be a mosaic or a patchwork of ownership across the province? This will be something new for us. Many of us once thought of a vast, publicly owned land base. This has been a fundamental of forest management in BC for decades. The picture that is emerging is not that simple. We will have treaty land, intermingled with title land, intermingled with crown land, and we shouldn't forget about the 4.5 million hectares of private land that's out there, and the roughly 14 million hectares of parks and wilderness areas, the no-go areas, and the communities, large and small, located throughout BC. Like I said, this is not going to be simple. And of course, the flora, the fauna, and the water, they know nothing about man-made boundaries. Neither do the mountain pine beetles, forest fires, or cumulative effects. One of the things about British Columbia that we all value is the richness of its natural environment. Are we going to be content in the future to have all these areas managed separately in an uncoordinated way with little or no continuity? Or would it be desirable to have some form of coordination, consistency? And if so, how might that coordination and consistency be achieved? What might it look like? How this developing mosaic is managed will determine the economic, social, and environmental sustainability and certainty in BC. In the case of treaties, this can be dealt with to a large extent in the terms of the treaty itself. For example, under the Nisga'a Treaty, the Nisga'a own the land and forest resources and can make laws in respect of the management of the timber resource as long as those laws meet or exceed forest practice standards under provincial legislation. On Aboriginal title lands, though, this is uncharted territory. It's worth remembering what the court said about the nature of Aboriginal title. It confers on the group that holds the exclusive right to decide how the land is used and the right to benefit from those uses, subject to the restriction that the uses must be consistent with the group nature of the interest and the enjoyment of the land by future generations. To what extent should the province be regulating, and what are the limits on its ability to legislate? It seems pretty clear that the province can pass laws of general application that apply to Aboriginal title lands, but there are significant limits on its ability to do this. Some important areas where the court said legislation is likely to be acceptable are protecting the environment, forest health, such as pests, and preventing forest fires. Based on that, it may be, for example, that the province could apply legislation such as the Forest Act on Aboriginal title land. FERPA, though, as it's currently written, won't work for title land because it regulates those who hold licenses from the Crown. Perhaps some form of general environmental protection legislation could work, dealing, for example, with such things as protection of riparian areas and fish habitats, soil conservation, and so on. How much of this should be handled through government regulation and how much through memorandums of understanding and similar cooperative agreements? I don't know. So what are some of the models out there today? One is the management framework on Haida Gwaii under the Haida Gwaii Reconciliation Act. This management framework is integrated with the Forest Act and the Forest Range and Practices Act. The Haida Gwaii Management Council determines the overall allowable annual cut and can establish land use objectives for the purpose of the Forest and Range Practices Act. Another model is the management framework for private forest private managed forest lands under the Private Managed Forest Land Act. This model includes a council that oversees practices with representation from landowners and government, as well as the objectives and the regulatory standards for soil conservation, water quality, fish habitat, wildlife habitat, and reforestation. Or is there a new model that brings key parties together across a landscape to form a cooperative or collaborative land and resource management agreement with the objective of sustainably managing a landscape across ownership types, tenures, and users? Models will differ based on the circumstances, but hopefully there's a consensus and continuity on key objectives and high-performance results. What does this mean for us as foresters? Will it be necessary to be a professional forester to practice forestry on title land? The Foresters Act is a law of general application. It regulates a profession, and it doesn't seem to matter who owns the land. With respect to consultation, arguably, the court decision raises the bar for consultation. The decision now gives a practical illustration of what consultation before a treaty or a declaration of title is about, something that may not have been well understood before. The reason for the consultation is that the land may turn out not to be Crown land after all. The court refers to a spectrum of duties applicable over time. For example, as the claim strength increases, the required level of consultation and accommodation correspondingly increases. An interesting illustration of this was in the news recently. The proposed Gambier Island woodlots, where the minister decided to decline accepting a winning applicant in the recent tendering of 2 woodlots on Gambier Island. In order to ensure that the province properly carries out its constitutional obligations, consistent with the Tsilhqot'in direction, as well as to address the public interest. This takes me to the topic of independent oversight, what we do at the Forest Practices Board. First, we audit forest practices. This means looking at the activities of forest companies, forest licensees, and the government in the field to see if they meet legislated requirements. We also make note of practices considered unsound, areas of improvement, and notable practices. Under the Nisga'a Treaty, the board was given a mandate to audit the activities of forest companies operating on Nisga'a land during the transition period, and was then asked by the Nisga'a to audit government's completion of forestry obligations on treaty lands. Next, we also investigate complaints. For example, earlier this month, we upheld a complaint from the Haida Nation about a failure to meet visual quality objectives and a lack of follow-up by government enforcement. Another important part of the board's mandate is to look at the appropriateness of government enforcement. That's because you can have good legislation, but if it's not enforced, it may not be effective. We also do special investigations and special reports on themes presented to us in audits, complaints, or through dialogue with forest stakeholders. The board has provided training on administrative law on 2 occasions to the Haida Gwaii Management Council, as well as office and field training and forest practice auditing to members of the Hetzluk. So, the board is a provincial government body, but it functions independently. The board's not part of any government ministry and does not get approval from the government before issuing reports directly to the public. We're required by legislation to conduct our audits independent of government and licensees. The board's got its own legal and communication staff, and so it is not dependent on government or subject to government direction in these important areas. So what are the benefits of the board's activities? Briefly, the benefits are an informed public and greater confidence. Markets for BC's forest products are objectively informed about practices in BC. There are informed decision makers. There is a higher rate of compliance with legislation. And there's continual improvement. All of these would be of benefit on treaty land or Aboriginal title land, or for that matter, all land, as well as all other tenures, permits, leases, licenses. The existence of this type of watchdog function demonstrates a healthy governance system with open, transparent, and accountable government that delivers objective, credible information. So in conclusion, as I began by saying, this and other court decisions have forced us in the short term into a reactive mode. It is not too soon to be thinking about the long-term picture and making plans for the future. There will be a growing patchwork of ownership types, governance capacities, and environmental objectives and standards across BC's landscape. The flora, the fauna, and the water will know no difference between them. As the stewards and owners of the land and resources, we will need to find the ways and the means to ensure that there is certainty for the people, the businesses, and our environment. As the Supreme Court said in its decision, it is to be hoped that Aboriginal groups and the provincial government will work cooperatively to sustain the natural environment so important to both of them. Thanks.
Thank you very much, Tim Ryan. Our final speaker is Tim Sheldan. Tim is the Deputy Minister of Forest, Lands and Natural Resource Operations here in BC, a position that he has held since October 2013. Prior to this appointment, he was 5 years as Director General in Edmonton at the Natural Resources Canada Research Station. And he may wish he stayed there, possibly, given this decision. Tim spent the majority of his career working for the BC Public Service for the former Ministry of Forests and Range. He culminated his career here as Assistant Deputy Minister of Operations from 2003 to 2008. He's held a number of different positions within the ministry, in headquarters, in the regional and district levels, at a variety of locations across British Columbia, in both the coast and the interior. He's also had experience working for the industry and consulting on the coast. And for a short time, he was a city councillor while in Merritt, BC. Tim graduated from Vancouver Island University in Nanaimo and is a graduate of a number of different management and executive development programs. He emphasized to me that he will not be giving government response, but will be giving small government, or small G government, as the civil service. Thank you, Tim.
Thanks, John, and good evening, everybody. It's a pleasure for me to be here. And just find a spot here. My eyes are not as good as Tim Ryan's, who looked at his notes without glasses, but unfortunately I need them. So very, very pleased to be here. Firstly, just to acknowledge the territory that we're on, the Musqueam First Nation. I'm also honored to be on a panel with Chief William, Jay, Doug, and Tim, of course, and all these individuals I know from various files. So, as John said, I'm the Deputy Minister of Forest, Lands and Natural Resource Operations here in BC. I'm very pleased to be in BC. BC is my home, so I was quite pleased to come back from Alberta, just so you know, although I enjoyed my time there as well. And what John was alluding to was a quick comment I made to him in the foyer. You know, I'm not here representing the elected part of government. I'm a public servant. Nor am I here representing the Ministry of Justice and Attorney General or Ministry of Aboriginal Relations. I'm here representing the Forest, Lands and Natural Resource Operations Agency, which is the primary agency in an integrated way which manages resource authorizations and forest land management in the province of BC. So that's what I was getting at. I do appreciate being invited to the panel, though, and you know, while there's all sorts of questions and comments and issues that are likely to arise in the final part of this evening, I think it's valuable to participate in these kinds of panels with the different viewpoints, with you know, talking about in this case a new Supreme Court decision as of last June, and you know, ideas are freely exchanged, and we all will hopefully learn from the dialogue tonight. So I was asked to provide an overview on the Tsilhqot'in decision tonight, and I will do so as I explained from the point of view of my responsibilities. Just a little bit of background, though, I think might be helpful. So I'm the deputy, as I said, of this ministry, but I'm also the chair of what we call the Natural Resource Board of Deputies. So the Forest Lands Natural Resource Operations Agency is the Crown manager of Crown lands and forests and natural resources in British Columbia. But we do that in collaboration with our partner agencies in the provincial government, Ministry of Environment, for example, Energy, Mines, Natural Gas Development. The Ministry of Aboriginal Relations and Reconciliation is a key member of that board, as well as others. So I'm also responsible to ensure that, to the extent we possibly can, from a regulatory and policy perspective, the natural resource agencies of British Columbia are integrated and decisions are made in a logical way and in a way that is connected and not in silos as we've experienced at points in our past. I guess I want to just talk a little bit as well about, and actually, John, you mentioned FP Innovation. I'm also on the board of FP Innovations as I'm the chair of Forestry Innovation Investment, which is a Crown Corporation responsible for working with the forest sector to help to market forest products internationally. So that's a little bit just about what I do. I don't think I've got a couple of notes about the way that the agency works, but I think we want to really get into the meat of what we were talking about here tonight. We operate under about 50 different pieces of resource management legislation, and as I said, we've got a role in most activities on the land base, and presumably that's why I was invited here tonight. Our staff review and make decisions on thousands, literally, resource management authorizations every year. And because these resource management activities take place on Crown land, the ministry is required, as my colleagues have said here tonight, to consult with local First Nations before decisions are made. So over the years, consultation and accommodation activities have been guided by the court decisions that Doug, you outlined very well in the history that you outlined. The most recent, of course, being the Chilcotin decision. I just want to agree with Chief William in terms of this decision. I think, Chief William, you talked about this being an opportunity to move to a new era of reconciliation, and I agree with you. This is an opportunity to move forward. I think it's important as well to recognize that the government of BC accepts the judgment of the Supreme Court of Canada, and in fact congratulates Chief William on this decision and the result. And the Premier has said as much, and the Premier has been to your territory and had numerous discussions with you as well. So I would just echo those congratulations. So in a forestry context, I want to talk about this for a minute. The ministry approves everything from issuing new tenures and cutting permits and road permits to approving forest stewardship plans at a more strategic level. As I said, we engage in consultation and accommodation with First Nations on these approvals. And the ministry will continue to base its consultation and accommodation approach on the jurisprudence that has been outlined here tonight, and most significantly the Haida decision and then the Chilcotin Supreme Court decision. When I mention the principles of the Haida decision, we consult First Nations, obviously when we have knowledge of an asserted Aboriginal right or title, and we're seeking to make a decision that may or may not adversely affect either of these kinds of claims. And I think it was Tim who outlined the sort of escalating process around consultation, the depth of consultation, depending on the nature of the issues and the rights and title discussions that we have with First Nations. Particularly, obviously, we look to enhance our ability to identify where asserted Aboriginal title or rights might be significantly and adversely affected by a government decision, whatever that might be. And in this context, I'm not necessarily only talking about forest harvesting. It could be any number of other Crown authorization decisions. And when we're required, as following the jurisprudence, the ministry will accommodate the First Nation if the consultation process and the dialogue between us and the First Nation determines that there's a duty to accommodate due to the serious nature of the impacts that may occur on the asserted Aboriginal right or title. It's our intention and that we will act in good faith. My ministry acts in good faith in exercising the duties, and will continue to strive for balance between impacts of a decision or a pending decision on the rights and title and other societal interests that we have to consider in balancing decisions. The impact of the Chilcotin decision in particular is we now have greater clarity on where strong Aboriginal title claims may exist in the province, a process for working to evaluate strength of claim and the dialogue that we need to undertake with First Nations as we undertake our decision-making process. We have tools that we use for accommodation, and there's opinions, I suppose, about the adequacy of those tools. It was mentioned earlier that we have forestry consultation and revenue sharing agreements, or FCARSs. Just a few facts and figures I think would be interesting. Since 2003, agreements have been signed with 177 First Nations that provide over $369 million in revenue sharing. And revenue sharing is one of the accommodation measures that we undertake with First Nations. Another accommodation is the provision of forced tenures to First Nations so that they can pursue economic development opportunities for their people, for their First Nation. David Walkham in the audience, obviously, and we heard in the awards ceremony the success of one such First Nations organization. So since 2002, we've issued 190 different tenure agreements with First Nations through our direct award program, and we've granted over 350 licenses with a total harvestable volume of 180 million cubic meters. First Nations have grown the amount of allowable cut that they control as well from about 1.3 million cubic meters in the mid-90s to 12 million cubic meters now, so it's a pretty significant change in a positive direction. The direct award program now represents about 9% of the provincial annual level cut. So as well as through increasing capacity and through partnerships and joint ventures with the industry, which is another element, First Nations have acquired control of about another 6% of the AAC through competitive award of licenses. So another tool that we use is the First Nations Woodland License. And this is a long-term area-based license that's designed specifically for First Nations to allow for harvest and management of non-timber forest resources. The First Nation Woodland License creates a new and flexible tool to help the ministry to meet its accommodation obligations. You know, we recognize the phenomenal growth of First Nations participation in the industry, but that won't be successful without First Nations members developing the skills to fully participate in the forest economy as well. So we've also participated in creation of the First Nations Forest Technician Training Program with provincial funding for a 2-year program for up to 10 students, which includes a mentoring program and employment with BC Timber Sales, for example. And as well as building capacity of individuals, the ministry's teamed up with the federal government to create the First Nation Forest Sector Technical Support Program. And so this program supports First Nations economic development interests in the forest and wood products industries and provides funding to develop business plans and explore new business opportunities. So that's kind of where we're at from particularly a forestry viewpoint. But we are only one ministry in government, as I alluded to at the beginning. We're beginning our work on strategic and operational responses to the Tsilhqot'in judgment. Part of the operational response is our ministry's approach to consultation and the adoption of a process to identify when asserted Aboriginal title might be adversely impacted by a government decision. So the province will be engaging with First Nations, key industry stakeholders in working to develop and implement a broader reconciliation approach. We've heard that word a few times in the presentations tonight. The province recognizes that First Nations need to be involved as we work to develop these new tools and enhance existing tools for reconciliation. In addition, industry has to be a key partner in helping to implement reconciliation as industry moves forward with resource development permits or projects. The province is also going to be looking at its existing set of tools for accommodation and impacts of development on Aboriginal interests, including asserted Aboriginal title. So the province may look to develop new tools for accommodation. I spoke about some of the ones we have now, or to work to enhance those existing tools, or provide better clarity on the appropriate use of those tools to our staff. So there's a multitude of activities that we are undertaking now and we need to continue to do and in fact expand beyond what we're doing now. So this is all part of the larger conversation that the province will be having with First Nations, with industry, on the development and implementation of enhancements to the HIDA consultation approach and the implementation of the Chilcotin Supreme Court decision in the short term. In the longer term, thoughts being given to ways in which we can enhance the possibility of reaching more comprehensive agreements or treaties, not limited to that process, but with BC First Nations. So the process of strategic and reconciliation at a significant level, rather than having discussions on sort of permit by permit, decision by decision activities. We need to make sure that we're thinking about the broader strategic and reconciliation-oriented approach to our relationships with First Nations. So as that begins to evolve, that thinking has to be the subject of discussions with our First Nations partners. We've certainly learned over the course of the various jurisprudence and court decisions that imposing something is not going to work. We need to work together. We need to talk about the approaches that we take with our First Nations partners. And we are looking at generating new ideas to help the province achieve reconciliation with our First Nations colleagues. So as feasible approaches start to crystallize in the balancing I talked about before with other societal interests, we will engage with First Nations and industry for input and guidance. The province wants to fundamentally continue on the path of reconciliation and the long-term vision of achieving treaties or other equivalent comprehensive reconciliation agreements based on a recommitment to negotiation rather than engaging in litigation with First Nations. So the province and the Chilcotin Nation have begun the process to negotiate a reconciliation protocol as outlined in the letter of understanding signed by Premier Christy Clark and the Chilcotin chiefs on September the 10th. We had another very significant meeting with First Nations chiefs, the Premier, full cabinet, and all of my deputy colleagues on September 11th in Vancouver. Chief William was also there, as was I. A very significant step, I think, in terms of talking about these things and the next steps going forward. Certainly was my perception that that was a successful day, and we had many good conversations with First Nations chiefs during that meeting. So it's still early days, Chief William, as you well know, in terms of the negotiations with the Chilcotin Nation. But I think that the foundation of reconciliation has its roots in righting an important and a historic wrong, as well as in the outcome of the decision, Supreme Court decision itself. So Chief William and Jay mentioned this earlier, but as some of you will know, or all of you will know now, the tragic hanging of the 6 Chilcotin chiefs in 1864 and 65 happened after the chiefs were invited to negotiate terms of peace to end the Chilcotin War. And it's remained a significant barrier to reconciliation, to trust between the province and the Chilcotin Nation. So on October 23rd, Premier Clark in the BC legislature made a formal apology and exonerated the 6 Chilcotin chiefs. So the apology was an important factor, I think, in helping the province and Chilcotin Nation take a significant step forward in terms of reconciliation and to build a relationship of respect and recognition. So the province wants to continue on the path of reconciliation, to continue to seek comprehensive reconciliation agreements such as treaties, while avoiding costly and time-consuming and divisive litigation. We recognize that we need the input and partnership of First Nations to achieve this objective. And the clarity that's provided by the Chilcotin decision may mean that adjustments are required for tools that the province has developed. I think each of the speakers have spoken of the Forest Act and how it does not apply now on Chilcotin title lands. So that's one significant piece of legislation and policy that now we have to determine where it applies, how it applies, what does apply in Chilcotin territory in the title area. And we're conducting negotiations and discussions on that very topic with the chief and his colleagues. So we also recognize that reconciliation is more than just implementing the Supreme Court of Canada decision and providing for implementation of that new relationship between the province and Chilcotin, but includes other factors like well-being and education to provide a foundation for the Chilcotin Nation in this case, and other BC Aboriginal communities as well, to build a strong, vibrant set of communities across the province. So while forestry is expansive and this province is covered in forest, it is not the only area, whether it's in the resource management area or in other disciplines, if you like, education, social services, all of those kinds of things that need to be discussed going forward. So I'd like to thank everyone, John, UBC Faculty of Forestry, again, my colleagues on the panel, and hopefully in some of the things I've had to say, have given people some ideas and some fodder for questions, I suppose, in terms of how we can work together in building this reconciliation that I think we've all been talking about with First Nations in this province. So thank you very much.
Thank you very much, Tim. We're now going to move into a discussion session. But before we do, I suggest everyone just stands up and stretches a little bit, because I know you've been sitting for an hour and a half, and it's probably some of you are getting a little bit stiff. There's one microphone at the front, so please allow time for the speakers to get the microphone. If you have a question directly for a particular individual, please indicate who you want the question to go to. And please, only questions. We don't need 15 minutes from any audience speakers tonight. Thank you. Who would like to ask the first question? Yes, we have one here.
Good evening. My name is Georgina Martin, actually Dr. Georgina Martin. I just finished my PhD here in the in the Faculty of Education. And I had a really good support. Dr. Joanne Archibald and Dr. Andre Mazawi are my co-supervisors. So I was listening to the presentation, and I don't have, the question is not directed to any person in particular. But what I wanted to find out with all of the developments that's going forward from this extremely important decision is whether or not there is anything being considered in respect to the culture or our connection to the land. And the reason I'm interested is because I'm supporting an elder from my community, and I'm also a Swep'em from Williams Lake. I'm Roger's neighbor, and I'm also a member of Lake Babine Nation. Anyway, I'm helping my elder to prepare her presentation to higher level bureaucrats and First Nations leaders in regards to the Mount Poly spill. And the one thing that she's really having difficulty articulating is the important connection to the land and the meaning of all of the resource extraction and the disruption that it's caused. So I've heard a lot more about the economic reality that we're facing. So I'm wanting to know if there's some kind of strategy to help us to articulate our position from that standpoint so that our elders aren't continuing to struggle to be able to educate and explain how important these connections are to Indigenous peoples.
This whole court case is based on our culture, our language, lands, resources, and environment, going back to the August 23, 1989, Tsilhqot'in, Nemaya Valley Aboriginal Preserve, Tsilhqot'in, is the big part of what we're doing today. The leadership of Tsilhqot'in adopted that. So in there, it's all about our lands, resources, how coming from our elders. The elders were the ones that developed the declaration, and the declaration is what we all followed to eventually this title case win. So just thinking of the Tsilhqot'in warriors, the leaders who sacrificed their life, they were hung for this. So that's really huge and really important. The economics to us is, being able to still be out on the land, hunt, trap, use in the land, medicines, gathering. Those are very, very important. So I think any economics coming out of this tidal win has to look at all that to make sure that it doesn't impact negatively and it's sensitive to our culture, our way, and Chilcotin people. So.
Thanks for the question. Maybe I'll just add to what Roger has said. It's my sense that the First Nations cultural and inherent attachment to the land, as you describe it, is part of the discussions we need to have in terms of the establishing what the interests are in that land base and what impacts a decision on resource management, whatever it happens to be, if it's forest harvesting or mining or some other kind of activity on the land base, will have. So when we're thinking about potential for infringement or what accommodation might be necessary to deal with whatever that decision might be. The description of how attached and what the impacts are of that resource management activity on the land base and the value that represents to the First Nation, whether it's an individual or a community, is an important part of the discussion and the dialogue back and forth that I was referring to in my remarks. So.
I just want to add another thought here as well, in addition to what's already been reflected back to you. The greatest opportunity of the decision, in my view, is that it creates the foundation for Indigenous peoples to reestablish their relationship with their territories and what that means in terms of their way of life and the opportunity for their culture to continue to unfold on their own terms in their own way. So much of what we talk about, from the Haida Nation decision and the duty to consult, it's all it's a very specific framework that's designed around Crown decision-making, proponents' proposals, and sort of this external reality to Indigenous peoples of us having to respond to someone else's business and someone else's desires to do something in our territories. That's a very specific kind of framework that's been in place, and it's one that doesn't in any way really create the foundation or the ground for First Nations to have their own positive source of authority and relationship with their territory, so that their territory and their lives can unfold, their culture can unfold in a positive way. So there's kind of two, the decision puts in front of us some short-term issues and some longer-term issues, and the issues are trying to figure out how do all of the existing patterns that are premised on a very impoverished conception of title, how do they need to change? So how does the duty to consult need to change? How does the environmental assessment approach need to change that's premised on a small spots theory of title? How do the FCURSA forestry agreements need to change that are premised on a very impoverished view of title? How do all of those different relationships and understandings need to adjust and change in terms of our work and obligation to protect our territories? That's the short-term issue. The longer-term issue is that the court has said Aboriginal title can live and breathe in the world. Doesn't have to be extinguished through a treaty process. It doesn't have to be extinguished to be recognized. It can actually live and breathe for the first time. And that opens up a really important opportunity for our elders to be aware of, that their grandchildren can live in a fundamentally different way than they have in their lives.
I'm Larry Joseph. I'm with Tsilhqot'in. I've been personally involved in negotiations at the Lands and Resources table with the Gitxsan people from 1999 to 2002. And one of the big things that we tried to do then was to reconcile the laws of British Columbia with Gitxsan law. And so my question for you and for the Deputy Minister is, when you work on this protocol, how far do you plan to go? Are you going to go right to the cosmology of the Chilcotin people and see how this is going to really embody the knowledge system of the Chilcotin people and their laws with the laws of British Columbia? So, Deputy Minister, how far do you plan to go on this is my question. And also for Chief Williams, you talked about, also secondly, you talked about tools that you would like to use. I'd like to ask also, do you plan to use the approach of free prior and informed consent that comes out of the United Nations Declaration on the Rights of Indigenous Peoples? This is an excellent tool, I think, that you should look at. And so I'd like to hear what you have to say about that. Just on the third point, I'm on the board of directors for the Forest Stewardship Council that's based in Bonn, Germany. And so we've been working on this approach as well. And we have some pilot projects that are underway in different parts of the world. So those are the questions I have for you, gentlemen. Thank you.
All right, sa Chanaya, as Tsilhqot'in people, this is a really very important question because Aboriginal title land win is huge. We're looking at not only the title land win, we're looking at the whole Chilcotin territory. And in front of us is an opportunity from this title win because in this title win, Forestry has no jurisdiction, Ministry of Force. From this moving forward to the whole Tsilhqot'in territory is negotiating an opportunity on how our relationship is going to continue moving forward from the title land win. So in the Tsilhqot'in, there has been industry harvesting for years.